Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights attorney Nicholas D. Krawec discusses preparing for trial.
Welcome. Today I would like to discuss the actual trial of a commercial collection case and what can be expected of you as the creditor or plaintiff in that process. At this point, obviously, suit has been filed. No deal has been negotiated with the defendant or the debtor, and an answer has been filed by the defendant denying liability and perhaps asserting some affirmative defenses, maybe even asserting a counterclaim against the creditor plaintiff. Also at this point, before going to trial, discovery probably has been done, perhaps depositions were taken, but the case could not be set up for summary judgment because there remain disputed issues of material fact that a judge or a jury has to decide. So you're going to trial. What can you expect? Well, first you can expect an investment of time and manpower, as well as expense, regardless of the nature of the trial, whether it's arbitration, whether it's a non-jury trial, especially if it's a jury trial. You will need to support the presentation of your case with the necessary witnesses. You as the creditor or plaintiff are a partner in the litigation. Don't look at the legal process as a black box where you've shoved it off onto the lawyer and they're going to take care of it. As I said, you're a partner in the litigation. What does that mean? It means invest the manpower. Don't take shortcuts with witnesses. What I mean by that is you've got to avoid the mindset that just anyone will do as a witness. You've got to avoid the mindset that you'll send who it's convenient to send. You've got to send the appropriate witness. And in the case of a debt collection matter, the trial witness for the creditor must be either a person who was directly involved in the transactions with the defendant, which are the subject of the lawsuit, or who in the ordinary course of their duties with the creditor normally maintain possession and custody of the account records upon which the claim is based and can testify as to their mode of preparation and their authenticity. So when selecting witnesses, you should avoid the notion that you can prep just about any employee as a witness. Why do I say that? Well, the witnesses will be subjected to cross-examination by the opposing attorney. So you got to ask yourself, is the person who I've chosen as a witness, this prepped witness, stand up under cross-examination? Additionally, this witness is going to be under oath. Can they properly and validly authenticate the account documents and their method of preparation and their maintenance as business records of the creditor? Do they have the necessary knowledge and records of the transaction and knowledge of the records themselves? During trial, you need to support your claim with your business records and account documentation. And the trustworthiness and reliability of those records is also key in a debt collection litigation. Not just the credibility of the witness, but the trustworthiness and the reliability of the business records on which you base your claim. Now, a credible and knowledgeable witness who can authenticate the account documentation and competently testify as to the procedures followed in their preparation and maintenance, and who can credibly and competently testify as to the details of the transaction with the defendant, is a critical part of the proof of your case in a debt collection context. You, as the plaintiff, will have the burden of proof at trial. In order for the trier of fact to find in your favor at trial, you must prove your claim by a preponderance of the evidence, and that evidence must be credible and trustworthy in the eyes of the trier of fact. As tedious as it may sound, you should maintain your business records and account records as if you are preparing evidence in the event you need to prove your claim at trial. So, in conclusion, if you are preparing to go to trial and you are a creditor plaintiff, expect to invest time and manpower and expense. Be sure that you choose the best possible witness having the knowledge and the credibility of the account, the transaction, and the records, and prepare to provide detailed and reliable account information and records to your counsel so that your case can be credibly and reliably presented at trial, and you win a verdict. Thanks for listening.
This has been another installment of the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.